Sycamore Meadows versus Caleb P.
Bill Bauer on behalf of Ms. P, Your Honor, who's also present.
Attorney Carrie Zanon on behalf of plaintiff.
All right, it's your motion.
Your Honor, we entered into a consent order. I brought printouts if you would like to look at it.
V.O. Wopo's right there. The judge is already skeptical, asking, how in God's name was I going to forget it? That's courtroom sarcasm at its finest. Translation, he's not buying excuses today.
Ms. P, you can.
How in God's name was I ever going to forget it? But go ahead.
Well, Your Honor, it said that Ms. P would be rehoused by July 31st. And if there were delays beyond plaintiff's control, that plaintiff would immediately contact me and a reasonable extension would be agreed upon. I was out of town when I came back and found out that Ms. P was unhoused. I started trying to reach out on July 31st to find out when she was going to be moved.
Actually, Judge, I think it's earlier than July 31st.
Okay. And I'm not trying to throw Ms. Zanon under the bus at all because she was very much communicative with me, but we weren't actually able to get any information about the move-in until August 8th. And we were told that Ms. P would be moved in yesterday. So Ms. P went yesterday to try to move in, and the first person she talked to didn't even know anything about it, and then someone else came out and they walked her through a unit that was not ready yet. So they told her to come back at 1 o'clock today, which she did.
What just happened? Ms. P signed everything, showed up on time, and still doesn't have keys. This is where housing law collides with real life. When landlords don't follow consent orders, judges can treat it seriously because someone's basic shelter is on the line.
And she signed all the paperwork and everything. And then they told her to come back at 5 o'clock to get her keys. She didn't know what to do. She knew that we had court. She came here for court, but she still does not have keys. I don't know why they didn't give her the keys at 1 o'clock and just say, wait till 5 o'clock to enter the unit. But she still does not have keys. And when she left to come to court, and she's using the bus, but she saw that there were 2 golf carts outside of the unit and it was still being worked on. So I just wanted to bring this before the court because they didn't follow the order. I mean, it was very simple to reach out proactively and say what this is going on, we need an extension, but instead she's been up in the air for weeks.
Can I respond?
Yes.
Judge, counsel's accurate. I did not have a move-in date until last week sometime. I was told that she'd be moved in on the 14th, which was yesterday. As to today's incidents, I actually talked to my client, and I was on speakerphone, and Miss P was in the office while I was on the phone with her. They were going through the move-in process. They had actually gone through a walkthrough yesterday. There was an exposed outlet that my client didn't feel comfortable moving her in yesterday. They had a conversation. They also told her that they were going to...
Legal insight, hear this, is why the keys matter so much. Until the tenant actually has possession, meaning keys in hand, the move-in isn't complete. No keys equals no legal occupancy. Judges hate these half measures.
Put the appliances in today, which is why the keys weren't handed to her, because the maintenance was in there putting the appliances in today. So my understanding was that they were going to do all of the paperwork today, and she was going to be able to move in once the appliances were completed, and they were doing that while she was in the office. So she knew that that's what was going on because she agreed that they could put the appliances in today. The keys have been cut. They're at the office. To speak to the time frame, Judge, I have 2 maintenance men that work there. That's it. And the complex is huge. And I have 1 on-site manager. When I spoke with the manager, and I just wanted the court to know that at 1:30, when they were doing the move-in process, I didn't want my client to up and leave and not complete it to be here. So I'm asking that the keys are ready to go.
Anything else?
Your Honor, I would ask at a minimum that they bring the keys to Ms. P here at the courthouse so that she has access.
That's not happening. Is there somebody at the office?
Notice the judge getting a little sharp here. Nobody's life operates that way. That's a warning. Shati's basically saying, quit making excuses, solve the problem. Judges love efficiency, and this one's patience is thinning fast.
Do we know?
Yes, but Judge, I will call if you want to pass, give me a minute, I'll call right now and make sure that where the key is going to be so that we know before we leave.
Quarter past a minute.
I just want to make a record. You're gonna have to take the bus back to 6
We hear that, but maybe the decision that should have been made is she could have done something via Zoom, something else so that she's there to pick up the keys if the keys were going to be ready at 5. These are problems that are being created that don't have to be. I mean, it would be nice if everybody's life operated as if legal services wanted it to on some great strict timeline, but nobody's life operates that way. So find out where the keys are.
I will.
I'll recall the case.
Thank you, Judge.
Forsnow versus Tequila Smith.
Thank you, Your Honor. Paul Hughes says LSSCM with respect to Tequila Smith. I'm pleased to advise the court that working with Ms. Bauer that we've come to a resolution that will resolve this case in total in the form of a conditional dismissal. Ms. Bauer has talked to Tequila Smith about this, and I understand that we're all in agreement. The conditional dismissal, if I can go through the terms real quick.
Yes, sir.
Rent is $1,392.32. That pays rent through August 2nd. We have a conditional order dismissal. Ms. Bauer has a copy there.
This is big no late fees for several months. Why? Because courts often give breathing room when tenants are stabilizing housing with third-party aid. That's a win for Tequila Smith and a strong example of conditional dismissals at work.
And she has my permission to sign it and present it to the court, or I can sign her name or Tequila Smith's name and email it to the court. The judgment is set aside that currently exists. The defendant will pay the $1,392.38 by 10/15/25. The defendant waives all defenses, including notice. The defendant waives the 56-day rule. The plaintiff agrees to accept third-party funding. No late fees will be assessed from July of 2025 through October of 2025 while she's getting her assistance. Tequila Smith will be dismissed without prejudice, so the agreement will be as to all occupants. And if 4B is checked on the conditional order of dismissal, Tequila Smith will be emailed a copy of the judgment in writ if such is required. Separately from that, I understand my client is recertifying to remove the child support effective July 1. And no late fees, I think we already talked about from now until October. That's our agreement.
Is that a correct statement?
Yes.
Smith of the agreement. Do you have any questions regarding that agreement?
No.
All right.
This has been signed by Ms. Smith.
Ms. Bauer, you can sign my name to that agreement if you like, and then the judge could, or somebody could.
Well, what I'll do, Mr. Hughes, with your permission, is it says that there's an S/ there. I'll just put my initials indicating your
Thank you.
acquiescence to that.
Thank you.
All right. And oh, hold on a second. Is this attachment to go with this?
Yes, Your
The
Honor.
further order portion? Got it.
I just wasn't sure which order to put those in, but maybe it should.
No, that's fine.
It's referenced.
Okay.
as
Your
an
Honor, if
attachment
Miss-
on number
If
3.
Miss Smith could get a copy of that before she leaves, she needs it for something early Monday.
Here. You don't have any questions regarding this, Ms. Smith?
No.
All right. And you're comfortable with everything that's in it? Okay. I do have to advise you have 3 business days to think about it. If you believe that there's some legal reason, some confusion on your part, or some right you didn't assert, you'd have to file a motion with the court within those 3 business days. Doesn't mean I'd set it aside, but you have that opportunity to do that. You understand that?
Yes, thank you.
All right. Fantastic. I will indicate this is conditionally dismissed. We'll get your copy momentarily.
Thank you.
You take care, Miss.
Judge, will I be mailed a copy too? I don't have,
Yes, we will do that, sir.
Thank you, Judge. Have a good weekend.
You do the same, Mr. Gray.
Thank you, Ms. Bauer.
Arbor Meadows versus Karen Contreras Hernandez.
Good morning, Your Honor, or good afternoon, Your Honor. I apologize. Michael
Way I'm
Burns.
going, you guys can see what's in. Way I'm going, it's going to turn into morning. But
I hope
anyway,
not.
go ahead.
Michael Burns, P87855 on behalf of plaintiff, Your Honor.
Your name
Karen Contreras Hernandez.
and what are we doing on this?
Your Honor, this was a termination of tenancy based on violation of community guidelines. Ms.
Yes.
Contreras Hernandez has brought the property into complete compliance, so we're happy to
We
report
just
that it...
needed to wait for her to get from overseas to do that.
Yes, Your Honor.
Because somebody thought I was going to kick out somebody in the military. It wasn't going to happen.
Correct.
Welcome back.
Thank you.
And so I have a dismissal.
Yes, Your Honor.
We're going to be done with this.
Yes, Your Honor.
You have any objection to that?
No, I do not.
Case is dismissed. That is without prejudice. All right. Thank you very much, ma'am. And again, as I think I indicated to you before, thank you for your service, you and your family.
Thank you.
All right. And it's a pleasure actually seeing you and not on Zoom
Right.
in some faraway location. But I will tell you, as I always say, I get to do what I get to do because of people like you. I appreciate it.
Thank you, sir.
Court calls the case of Beal Properties versus Melissa Daly.
Good afternoon, Your Honor. Michael Burns, P87855 on behalf of plaintiff. Bar numbers. Yeah.
I guess it's going to be Melissa Daly, Carla Hardman, Cindy Hardman.
Judge Dominic Camden appearing on behalf of the defendant, Mrs. Daly, who's present, sitting to my right.
Okay. Hello.
The complaint, counter complaint filed in this case, Judge. We've spoken to each other in the hall and have been unable to reach a resolution in this case.
Oh.
So I do have a procedural question. The complaint to evict is a summary proceeding, but the counter complaint is not. Counter complaint is related to a breach of habitability, as well as breach of the requirement, quiet enjoyment, and then basically a wrongful eviction, which I think entitles me to a certain degree of discovery. And so the question that I have is, you've got a summary proceeding, but you've also got
They're only allowed discovery in district court if I allow it. But
and that's where I'm going.
yeah.
So I'm looking for some form of discovery on this case.
What is it you're specifically looking for?
Well, the property was left in a significant degree of disrepair, and I think counsel is going to indicate, I'm not trying to advocate for him, but I think he's going to indicate that my client caused it. My response is going to be that it was not caused by my client, that it was basically left in significant disrepair by the landlord. There's also some communication that's been going back and forth from Section 8 with regard to their failure to keep the property in a habitable condition so as to allow my client to enjoy Section 8 and to allow that funding. And so I'm going to want some discovery there as to communication back and forth between Section 8 and the plaintiff.
Response, Your Honor? I don't think I'd necessarily object.
Boom, here's the twist. The tenant has proof that the landlord approved her emotional support animal. And in housing law, that changes everything. Question for you, you think landlords use unauthorized pets as a shortcut to evict even when they know the law.
To the discovery related to the counter complaint. But as it goes for our initial complaint, it involves an unauthorized occupants and unauthorized animals on the premises. It's a pretty straightforward case. We believe our proofs are more than sufficient. As it relates to